Guys, this hearing opens with a dispute over a temporary order preventing relocation and other family law issues, and right away, the tension in the room is noticeable. Counsel for the father, Blake Chesalon, steps forward and begins explaining the situation to the court. According to him, the opposing party filed a response extremely late, just the afternoon before the hearing.
And Your Honor, Blake Cheselden, again, reintroducing myself with Ken Miller and Associates on behalf of Mr. Sieber. And so this is our motion. I'm not sure if the court, when it was reviewing the documents, took note. We received Ms. Siever's response yesterday afternoon, I think at like 2:52 p.m. And yes. So I don't really know what the court wants to do. I anticipate that Mr. McGee would like a continuance. He hasn't communicated that to me, so I'm not trying to put words into his mouth. But if the court wants to take this case up on the merits today, I have to object to their filing. I haven't had a chance to reply to it. And so if the court is going to take it up today, I'm not sure if there's anything else that the court can do except grant my client's motion. Because, I mean, these filings were late and my client hasn't had time to provide a reply.
Yeah, I agree. Nothing should have been filed yesterday because the strict reply is 2 days before, but we
Exactly.
got a lot of filings yesterday, which is a violation of the local court rule. But with that, then, are you asking for a continuance, Mr. McGee?
Well, Your Honor, I'm not aware of that late service. I apologize to Mr. Cheselden and his employer that if that was the case. I wish I had an instant explanation for that, but I don't. I'm going to have to look into what the issue is there. And I apologize. I mentioned earlier, a lot of times it's usually continuance is fine with me, Your Honor. I think it's appropriate.
I will take into consideration what you filed yesterday. So we don't need continuance, but I'm not going to take into consideration what was not timely filed. So we can hear just not on what was filed yesterday with counsel.
Yeah, Your Honor, is there a possibility that we can call this after the break? I am sorry. I need to find out what exactly went wrong with this. I don't know or if anything is wrong.
I can tell you there was filings with the court yesterday on this too, that the court's not taking into consideration because it's late filed. But this is our last case on the docket. So we can just go on merits, but I'm not going to. And our local court rules are clear that if you do file late, which it was, the court might not take it into consideration, or there could be other ramifications for that. But for right now,
Your Honor, I'm happy if the court would continue it a week. I'm happy to pay out of my personal pocket, because apparently we made a mistake, Mr. Cheselden, $200 for the hour of time that he had to expend here. Because I'm not I think the court wants to hear this on the merits, not on the we've put a lot of work in this case, getting it out of, by agreement with the opposing party, getting it out of Wahkiakum County over to here. I mean, we've done a lot of work on this case. We've done most of the work, and taking that into consideration, our diligence in shepherding that through, so the other party didn't have to do it. I think I would hope we'd be given a little bit of consideration on that point. It's an unusual case because it was transferred in from a different county, and I did all the work on that.
Let's hear from counsel. Counsel?
Well, I'm not going to dispute that. By agreement, we moved this from Wahkiakum to Grant County. It took a while to get it moved here. And I also acknowledge it took a little while to get this hearing finally noted. But I guess that's another reason why, I don't know why I didn't receive the responsive materials until yesterday. And I think that Ms. Siever's declaration was signed like in early February. I don't remember the date that is shown on the declaration off the top of my head, but I want to say it was like February 7th. And so I don't know what happened. I object to a continuance because this has already taken a while, and my client hasn't seen these children or his children since the Miss Siever moved in early January, which was before the date that she even listed on her notice of intent to relocate. And her notice of intent to relocate didn't give him 60 days notice either. And so there's a lot of stuff going on here, and another week is another week that we don't have a workable parenting plan in place, or an order on whether the move is going to be approved. I understand the position that Mr. McGee is in. I don't know why these things weren't filed, but I also understand that the court probably wants to take this up on the merits, but I have to object to a continuance. And if the court is going to continue it, I appreciate the thought by Mr. McGee, but I bill at $275 an hour, and I've already been sitting on this docket for 2 hours, and then I had to prep for this hearing this morning. So it was more than an hour of my time.
All right, give you a moment. You still up in Electric City?
Cooley Dam. Yeah.
Sorry, Cooley Dam.
Yes, ma'am.
What's your work schedule on Fridays, sir?
I am retired.
Okay.
Oh, Your Honor, I realized that I misspoke when I was describing how long I had been sitting on this docket. This docket started at 9, and I said I had been here for 2 hours. That is incorrect. Just wanted to correct the record.
After listening to both attorneys, the judge pauses to consider everything that has been said. A brief exchange about scheduling and record corrections follows, but the judge soon shifts the focus to the bigger picture. From the court's perspective, there are several serious concerns in this case. The most pressing one is the relocation itself.
All right. Okay. There's a few issues here. First and foremost is there is a plaintiff who chose to disregard the rules and just relocate without a court order, and that is not acceptable. They've been disregarding the parenting plan for a while now. I did, for the record, review everything that was filed up until yesterday, which none of that was timely. I didn't have a chance to read any of that. So what I'm going to do is I've indicated here that Ms. Seaver moved for a continuance, and my finding is that Seaver was not timely in filing with the court or Mr. Seaver, and the children were relocated without agreement or a court order. My order today is that Ms. Seaver shall provide for a visitation with Mr. Seaver and the children on Friday, March 13th, 2026 at noon until Sunday at 6 p.m. within 50 miles of Cooley Dam. Plaintiff shall pay $275 cost for untimely filed. The visit is unsupervised. And the hearing is going to be continued until March 20th. Those children need to be back here for their visit. I want to make sure that that is clear to all the parties. And I want to make sure that it is clear that everybody understands that under the civil rules, the local rule number 7 gives exactly what the dates are and the timelines are for responsive documents, for filing documents. And under subsection 3, a strict reply document must be filed and served at least 2 court days prior to the date noted for argument on this motion. Everything that was filed yesterday in this case was clearly not timely, and time is of the essence, as Mr. Seaver did not have any visitation or has had any visitation for months. That is unacceptable. So that is my order for today. I'm doing 2 weeks because of the visit next weekend. Want to make sure it's very clear that that needs to occur. And then the costs can be paid within 60 days.
Well, Your Honor, I'll get a check out to Mr. Chiselton today.
And I am not doing, and sir, I'm not doing for your time prepared. You had to prepare anyways. You're prepared and you'll be ready in 2 weeks. So cost.
That's fair. Your Honor, could I just have you reread what your order was? I can only type so fast.
Yep, no, that's okay, and I talk fast. It is ordered. Ms. Seaver shall provide for visitation with Mr. Seaver. Am I saying that right, sir?
Yes.
Okay. And children with Mr. Seaver and children on, right, for visitation with Mr. Seaver and the children on Friday, March 13th, 2026 at noon until Sunday at 6 p.m. within 50 miles of Cooley Dam. Defendant's visit is not really a defendant, you're a respondent, but that's okay. I'm just putting visit is unsupervised. And then, Ms. Seaver shall pay $275 costs for untimely filing and continuance. Hearing continued to 3/20/26 at 9 a.m. Cost paid within 30 days. So that's all we can do today. I did want to address this on the merits. Unfortunately, because of the late timing of the filing, we can't. However, there has to be that visitation next weekend. All right.
And Your Honor, do you?
Can I just ask for clarification? You know, the court's clearly aware that the extant parenting plan requires supervised visitation. Is that the only provision that's being relaxed for this one time?
For right now, this time, and then it'll be addressed on the 20th. Okay. Sorry. So do you have another question?
I did. Does Your Honor want my office to note up the hearing on the 20th, or is the court administratively continuing it?
Administratively continuing it, so you have to note it up. Okay, sir?
Thank you.
All right. Everything else in terms of visitation and everything will be addressed on the 20th. But for now, that visit must be occurring next Friday at noon. Okay?
Thank you.
And
thank you, Your Honor.
The last item that we had on the docket for today.
Before closing the matter, one final question comes up about the existing parenting plan, which previously required supervised visits. The judge confirms that the unsupervised visit is only a temporary adjustment for this specific weekend and that the issue will be fully reviewed during the next hearing. The judge recalls having seen this same couple before and notes that the dispute has been dragging on for quite some time. From the court's perspective, it has felt like progress has been difficult and solutions have been slow to appear. But for now, one thing is clear. A visitation is finally scheduled, and both parties will return in 2 weeks to address the larger issues surrounding relocation and parenting arrangements.